sooner we get to the end of that information, the sooner we get out of here. So, all right, during the break, I had a bunch of questions. I've gone through them. They're all good questions. And truly, this is to benefit you, so if you would give me questions, I can hopefully give you some answers. You know, the last time I was here, I talked about ag teachers and teachers that teach cooking classes, some of the classes that have elements of more danger than a math class would have, okay? Don't see many protractor injuries and ruler injuries. English words generally don't hurt anybody. My daughter's doing a paper on Beowulf right now, and I'm about to hurt somebody helping her with that. If you haven't read Beowulf since you got out of high school, you might want to take a peek at it again. It's still just as bad as it was when you were in high school. And then you have to write a paper on the symbolism that was in Beowulf. Oh my gosh. All right. Some of these questions are good questions. What about when we have students walking around the campus? The campus this size, you've got different buildings, okay? How do you handle this? How, as a lawyer, do I recommend that you handle this situation? Well, first of all, the number one rule on student supervision is that the level of supervision and the type of things that you need to have in place will depend on several things. Number one, the age of the kids. So if we have students that are going from the cafeteria to the classroom, and we're talking about the itty bitties, that's when the teacher's going to line them up and walk them to the cafeteria. As the kids get older, that level of supervision decreases. So when we get to the point of a high school setting or a junior high setting where the kids need to go from the main building over to a band room or to a performance room or to the football stadium and all, I think, in my opinion, that it's going to be sufficient that a teacher not to walk with them as a group. But if we have someone at the receiving building standing by the door, and if you have someone on the leaving school, and if they take roll in both locations to confirm that all the kids have made it, then I think we're going to be fine. I don't think we have enough teachers to send a person to walk with a student around the classroom, okay, or around the campus. So the first thing is the age of the kids. The second thing is the layout of the campus. I'll submit to you that the campus we have here is one of the more safer ones in the sense that we're off 165. We don't have a cesspool in the middle of the campus. We don't have a pond. We don't have a railroad track near here. Now, if any of you are on a campus that has a railroad track, a busy street, or a pond, and we're dealing with little kids, we're going to have a much higher level of supervision on that campus than we would here. So again, just to be honest with you, it's going to depend on the age of the children and the type of campus and the campus layout you have that determines the level of supervision that you have. If you're dealing with older kids simply moving about the campus, I don't think we're going to have a person walk them from one location to another. These are good questions that I invite. What about teachers that take their cell phones out at recess when they're supervising kids and they're on their cell phones? Well, supervision is not mere presence. To be engaged in supervision means that you're actually engaged in watching the students. Okay? So one thing that drives me crazy is when I look at a video on a playground and we'll see 3 or 4 teachers huddled together talking and all these kids playing out there. The teachers ought to be spread out. They ought to be actively engaged in the supervision. And being on the cell phone and checking Facebook and texting and all would not, in in my opinion, be in the active supervision of the students. I drive every day past Lexington Elementary School in Monroe, and I see that the duty teachers are wearing hunter's orange vests. And I've talked with Brent Madreen about that. He says it's two things. Number one, it makes it easier for the principal to see the teachers spread out. But number two, it also allows the kids to find the adult if they have a problem. I mean, we're talking about a playground with a bunch of kids on it. And so the teachers with those hunter's orange vests stand out, and the kids know who to report to. So that's something that they're doing there. So we had that situation. What do you do if you're driving a school bus and a fight breaks out? I'm going to tell you what to do, but I'm going to start off by telling you what not to do. In a certain parish that resides on I-49, the husband is driving the bus, the wife is asleep on the front seat, she is the supervisor, and they're going on a field trip to Shreveport. Going to sleep on the bus or on the playground is not actively engaged in supervision. But being a married man, he knows that you don't wake up a sleeping wife, okay? So he's driving the bus, and he looks in his rearview mirror, and there's a fight in the back of the bus. So he stands up, holds the wheel with his left hand, tells that kid, hey, you slip in under there, you drive for a while, and we'll go back here. So the kid's driving the bus down 49, the bus driver goes to the back of the bus to break up the fight. Now he's got to be on schedule, he's got to break up the fight. So sometimes, So anyway, he goes to the back of the bus. Well, the kid is scared hoopless. And the kid has more sense than the driver. He gives a signal, turns onto the shoulder, and stops by the grace of God, because somehow that door comes open, and one of them goes out the back door of that bus. Okay? So, to answer the question, you do not allow another student to drive while you go address the fight. You give the verbal warning and the verbal directive for them to stop. You signal and you stop the bus, kill it, and then you go back and try to break it up. But I'd say that bus situations lead to some of the best lawsuits. I gotta tell you. We have had so many problems on buses. We've had situations where the boys on a basketball game, the boys would sit at the back of the bus and the girls would sit at the front of the bus, and they would put a coach in the middle. Well, both teams won one night, and they were all celebrating, and they were having a merry old time coming home, and the coach in the middle wanted to talk with one of the coaches at the front of the bus. So the coach goes up to the front and tells a young lady, hey, go take my seat. I need to talk with Coach so-and-so. Well, the young lady goes back to the back of the bus by the boys, and you don't have to use your imagination to know what might happen back there to about 3 of those boys. And there's a lawsuit filed. Long story short, the school district had to pay $250,000. Now, the Paul Harvey of the rest of the story is that this student was a special ed student that had inhibition. I don't know the term for it. She did not have the normal sense of, ooh, I better not do that, okay? So she had low inhibitions, and she could easily be talked into things, and she was. And so the court said that the school board knew that this student suffered from this exceptionality, yet they still breached their own rule and from separating the boys and the girls, and the coach abandoned his duty spot, went to the front of the bus, sent the girl to the back, which was the direct cause or the indirect cause of what happened. And so the school bus the coach was found to be liable, and then the school board was found to be liable. Now, one of the questions that I've got here is, what happens in those situations where the school board is liable for the acts that the teacher did? So let's say that you're not on your duty post and a child is injured. Let's say that you're the coach and you get up from the middle of the bus and you walk to the front of the bus and send that girl back, and she does something that she later regrets. What happens in those situations? Well, what happens is the school board comes in and hires an attorney to defend the school board and the teacher. And as long as there is no element of an intentional act, then the school board will defend and identify the teacher. Okay? Now, what happens if a teacher intentionally hits a kid, or if a teacher, in the examples we used earlier, makes that kid do all those sit-ups or all those push-ups? In that situation, I think the teacher may be on their own because they have done things that were designed to embarrass or to hurt the child, and they would lose that immunity. But that's not the full story. If you are not on your playground post or duty post, or if you leave your classroom for no valid reason, I think that you could be looking at termination or the loss of your job for something like that. So, to be just 100% honest with you, the school board will hire you a lawyer to defend you as long as you don't hurt a child or embarrass a child intentionally. But you will have some repercussions for the neglect of duty that you caused. I'll give you a couple of examples. Taking a kid into a closet and paddling them without a witness and all. We've had a case on that. The kid was bruised all up, and the court said that was intentionally hurting a child. We've had situations where teachers taped kids to a desk, and they put a piece of tape over their mouth, and they had an asthma attack. The court said no protection there. We've had teachers that kicked students with their foot, no protection there. So these are the type of things where if you're sued, you're going to be on your own, and you're probably going to lose your job, okay? But taping a student to the desk is a big no-no. All right, so if you have the fight, use the common sense. It depends on the age of the child and the location, but as a bus driver, never let anyone else drive the bus. All right, let's see here. What if you are a bus driver and you're having trouble with a student who you know to be a special ed child? He won't sit down in his seat. He wants to instigate fights. It becomes a safety issue where the bus is moving and the child's not staying in the seat. The IEP team needs to be reconvened. We need to take a look at these situations, and it may need to be an alternative transportation offered to this student on a sped bus where there are paras and other things to ensure the safety of that child. The parents cannot unilaterally say, my child is riding the special ed bus, the regular ed bus. That will be a decision that the IEP team makes. And it may reach the point where you could say, look, we've offered you transportation, which is what we're required to do. You chose not to avail yourself of that transportation, so you will have to deliver the child. But again, the long and short of it is, this is going to be a decision for the IEP team. They will need to reconvene and reassess that situation and take a look at that. So that was another one of the good questions that we got. Staff using cell phones on duty and playground, we talked about that. In regards to playground duty with young children, there are several people on duty with assigned position. If a teacher is not at her assigned position and an accident occurs, will she be liable, or will it be the other teachers that are there? So the answer there, I think I've already answered, is the person who is not there is going to be in trouble job-wise. A lawyer will be hired to defend everyone. Those of you that were present will be immediately dismissed from the case. The one that was absent will be left in the case, okay? And let me tell you how that happens. There's a law that was passed about 5 years ago that said you cannot even sue a teacher for an injury that a child sustained as long as the teacher was doing their job and was not violating the board policy. So as it relates to an injury on the playground where one teacher is absent, then that teacher will be sued. They will be in the lawsuit because they weren't on their duty post. The ones that were on their duty post will be dismissed. So the case may start out so-and-so versus Caldwell Parish School Board and teachers A, B, and C. And once it's done, once we file our motions to dismiss, it'll be parent versus Caldwell Parish School Board and teacher A. The other two teachers that were on job doing their duty will just be immediately dismissed. Now, that doesn't mean that the teacher that's left is going to owe anything. It doesn't mean that we're going to lose the case. But we have this mechanism to immediately, like within 30 days, remove those that were there doing their job correctly. And so that's the carrot, if you will, that the court awards those folks that are there doing their job. So they'll be dismissed from that lawsuit very quickly. Now, to the extent that I may have confused some of you talking about the sign-in and sign-out procedures, I want to apologize. If you need to follow whatever directives your principal sets at your school. So to the extent that I said sign out here, sign out there, and at your particular school that's not an option, then you need to follow the directives given you by your principal. I have a principal now that has not been arrested, but is in hot water with a couple of the teachers because the audit found out at this particular school that teachers were signing out as though they left at 3:15, yet they were leaving at 2 and 1:30 in certain circumstances. Yet they were not being docked for the time that they were missing. So that sign-in sheet needs to be accurately reflect when the people are coming and when the people are leaving, because this is not simply an issue of covering, this is an issue of public payroll money, okay? And so you're being paid to work X hours to X hours, and if you are leaving before then you're being paid for time that you're not working. So that can be an extremely delicate situation there. So I wanted to call that to your attention. We have problems with securing facilities in some parishes. I want to call to your attention the principals that you need to check, custodians, you need to check and make sure that the buildings are locked. I know that there have been some very inappropriate pranks done. I think of one in this very auditorium that several years ago where I think you could have fished up here. Okay, there was enough water in here. Some kids put some garden hoses in the windows, cut them off. So we need to make sure that our facilities are locked, and our access to the campus is locked, and because that is extremely important. We're getting calls from state police about the enforcement of the new law relative to kids going in the back seat instead of the front seat. I think it's now that if the kid is under 13, they got to be in the back seat. And when they come through the drop-off lines or the pickup lines, the state police are saying that some teachers are putting those 10, 11, 12-year-olds in the front seat. What the state police are encouraging us to tell you is that we want you to put the kids of this age in the back seat. Now, if the parent wants to stop out there on the road and tell them to get up front, that'll be on them, okay? But we need to put the kids of that age in the back seat. Another complaint that we're getting from the state police is that some principals or teachers are telling the kids, telling the parents, once you get in the drop-off line in the morning, go ahead and unbuckle your car seats for the little bitty ones. And that way, when you pull up in front of us, all we'll have to do is grab them and take them out. The state police are saying that as long as that car is in motion, then they need to be buckled. And they have worked some serious accidents that have happened in the drop-off line and the pickup line. And so we don't want to be in a situation where we have a lawsuit because it was the quote, policy or practice at school to make us unbuckle those kids before it was time to. So it's gonna take a little extra time, but please follow that request, when you're asked, about that. All right. I want to talk to you and kind of give you a historical perspective. We're going to move on into some personnel matters. But everybody out here, and I know we have a couple of board members here, we've heard about Act 1 in 2012. And we generally know what Act 1 does, but I want to talk about what happened before, what was in place before Act 1, what Act 1 did, and then what this new law, Act 570, did, to kind of give you some perspective. You know, when you acquire tenure in this parish, it's only in this parish. I did a presentation last week, and had a person come up to me afterwards and said, look, I just came to such and such a parish. I taught over there for 20 years, so does my tenure come with me to this parish? And the answer to that is no. Tenure doesn't transfer from parish to parish. It is earned in each parish. Well, for 100 years, literally it is right at 100 years before Act 1, once you taught anywhere for 3 years and you were a certified teacher, boom, you got tenure. If you were a principal before 1985, you tenured as a principal or as an assistant principal. But gradually, the law started changing, and in 2012, Act 1 was passed. And what Act 1 did was it took all the power that had been vested in the school board, and it put it in the superintendent. The governor at the time, Jindal, and John White and that group thought that school board members did not know what needed to be done from an educated perspective. And they thought that teachers were the problem, and that if they had the ability just to get rid of teachers, the test scores would miraculously start improving. And so what it did was, in my opinion, now this is my biased opinion, it set school boards and superintendents on a collision course. And school boards started resenting superintendents. And because the power that they had was suddenly placed in the hands of the superintendent. Because, see, constituents call board members and they say, oh, teacher so-and-so, they're not doing this. I want you to do something about it. And board members say, I don't have the authority to do that. Or someone calls a board member and they say, look, my son needs a job and he's a certified teacher, can you hire him? And the board member says, I don't hire anymore. Or one of you don't like the fact that you're transferred from one school to the other. You call your board member. The board member says, I don't handle transfers anymore. All of that power was placed in the superintendent's hands. And you had, for a long period of time, superintendents, and I still consider your superintendent to be one of those old farts, that have been around. They understand that even though they have the power, they need to communicate with the board about their decisions. I'm going to do this, I'm going to do that. But as we get more and more younger superintendents, and I hope that I'm talking to some of you in this room, I hope that there are principals in this room that aspire to be superintendents, and I hope there are teachers out there that aspire to be supervisors. I want this to be useful to you so that you know that once you become a supervisor, once you become a superintendent, you don't need to adopt that philosophy that Act 1 took all the power from the superintendent and gives it to me. Me. I make the decisions. If you adopt that approach, you're not going to be successful and you're not going to be in your position very long, okay? But Act 1 changed 100 years of the law. It did away with the concept of automatic tenure after 3 years. It did away with the principle of the concept that the board made all the decisions. It said that we no longer have tenure hearings to remove tenured teachers. What Act 1 did was really, really unfair. It said that if a teacher was to be terminated, the superintendent would make the termination decision. And if the teacher wanted to challenge that, the superintendent appointed someone to a 3-person panel, the principal appointed someone to the 3-person panel, and the teacher appointed someone to a 3-person panel. Now think about this. 3 people. The principal that recommended your termination gets to appoint someone. The superintendent who just terminated you gets to appoint someone, and you get to appoint someone. It doesn't take, I forgot who I can figure that out. It's going to be a 2-1 decision. But it's even worse than that. What Act 1 said was that if that panel disagreed with the superintendent, all they could do would be to make a recommendation back to the superintendent. Mr. Superintendent or Madam Superintendent, I think you messed up. I would recommend, or we would recommend, that you reinstate the teacher. It was a recommendation only, and the superintendent could say, thank you very much, I agree with my first decision. So Act 1 was problematic. And that was passed in 2012. So as a result, in 2014, they changed the law, and I think much to the better. Under the current law, if you're a tenured employee, the school board has to have 5 names, and they have to be retired judges or lawyers. And they put those people's name in a hat. And if you are terminated, they reach in that hat and they pull out the name of one of these people, and that person serves as the judge, and you can get a hearing before that judge, okay? And they hear the case, and they make the decision relative to your termination. So that is Act 570 that we work with now. And under Act 570, teachers, again, just like Act 1, you don't get automatic tenure after 3 years. You have to be highly effective for 5 out of 6 years. If you're ineffective in 1 year, boom, you automatically lose your tenure. You have the right to a hearing before this very hearing officer or judge to review the superintendent's decision. But they also expanded the area. So now, under the current law, bus drivers no longer get tenure. So if you were a bus driver prior to 2012, you keep your tenure. If you were a bus driver hired after July 1, 2012, you can never get tenure. So this new legal regime that is in place in education is totally different. So there is basically no tenure for bus drivers, and the tenure rights for teachers have been grossly curtailed. And so I want to tell you that because I think it's important for you to know how your rights have been affected by this new law. Now, for principals, they changed that law too. You can no longer acquire tenure as a principal. You can no longer acquire tenure as assistant principal or as a supervisor. All that tenure is gone. It's all now a matter of contract. And if your termination is sought in one of those administrative positions, you don't go to the board. The board is out of it. You only get the hearing before the disciplinary hearing officer, just like a tenured teacher. So for all practical purposes now, the school board is involved in no terminations of anyone except the superintendent. The school board is involved in no hiring of anyone except the superintendent. The school board is involved in no evaluations of anyone except the superintendent, or even transfers. But you as the employees can, you don't go before the board anymore either. You go before a disciplinary hearing officer. So that's the situation there. Now, the other big thing that you as employees have to watch for are the ethics code and the ethics provision. Every one of you in this room should have had or shortly be receiving your 1 hour of training in ethics. And I will not give a legal opinion on ethics issue because, I try to use common sense too. And you cannot use common sense as it relates to the ethics code because common sense and the ethics code have never met. So you can be the principal of a school. What's your father's school, John? Kelly? All right, let's say that you're the principal at Kelly and there's a convenience store straight across the street from you, but your brother owns it. And your brother wants to will sell you gas for the lawnmower at his price. So he can say $2.50 a gallon out there on the sign. And he'd say, I'll sell it to you at my cost, you know, $2.45. There's not much markup on gas, if even that much. I'll sell it to you at cost, and that way you don't have to drive back to Columbia to buy it. The ethics board will say you can't do that. The ethics board will tell you that my friend Butch Williams, the C superintendent over in Webster, he bought a box of chin straps for his football team from his brother's store in Minden, paid cost for it instead of driving to Shreveport, and they needed them right then. And he got fined like $5,000 for that. It is absolutely ridiculous. We had a situation in this parish many years ago where a cafeteria supervisor retired. Shortly after she retired, there was an illness on the staff at the school, so they asked her to come back and serve on the line until the lady was well enough to return. And her son was on the school board, and the ethics board fined them. And the son on the school board didn't even know that his mom had gone down there and worked a couple of days. So it is just absolutely incredible, some of the things that the ethics board is doing this day. There are limits on the amount of gifts that a teacher can receive from students now. They're looking at that. We have to be very careful on the trips that you may be offered. Let's say a textbook company wants to offer you a trip to such and such a place, and they'll pay for your airline and your hotel. We have to get approval on that before you do it. There's severe restrictions on what they can offer you. If you're a teacher of the year or principal of the year, and different groups say, hey, come talk to our group and we'll pay you $500. There are serious restrictions on that. Textbook companies wanting you to come talk at their seminars. If they have a contract with the district, then that can be problematic. I'm dealing with a situation in another parish now where a state teacher of the year would take a professional leave day, and he was telling his principal or her principal that she was going to professional development, when in truth and fact, she was on the agenda and was speaking at that professional development and being paid $500 a day. So the school board was paying the teacher thinking they were going to get professional development when the teacher was actually making money through that situation. The ethics board had a problem with that too, as did the school district. We also have found teachers that are using their school email address to run their private business on the side while they're at work. So the ethics board and the school board have a problem with that. So the lucky thing is there's this 1-800 number that you can call for the ethics board. It's on their website. If you just Google the Louisiana ethics board, you can get that 800 number, call that 800 number, and they will put an ethics attorney on the line. They will talk to you and they will give you an opinion right there. And you can write down who you spoke to and the time you spoke to them, and that'll give you some protection. If they feel as though it's a complicated issue, they will put it on the agenda of one of their ethics board meetings and give you an opinion on it. You know, it is so broad and so encompassing that if your spouse, one of your spouses out here has a business that, let's just grab one out of the asphalt, or pours asphalt, awnings, computer services. If your spouse has one, we have to be very careful about your husband or wife doing business with the school board, and we have to get opinions on that. So I don't want to scare you, but I just want to tell you that the common sense and the ethics code have never met, and so you might want to take a look at that. Now, let's talk for a second about immunity. We've talked about lawsuits and how you can be sued and this, that, and the other. If you really stop and think about it, I've told you that as long as you're doing your job, you can be automatically dismissed from lawsuit within 30 days. It's only when you're not doing your job or if you're violating the policy that you've got a problem. That immunity applies to corporal punishment when you're spanking kids. It applies to injuries on the playground. It applies to injuries on field trips. It applies to everything. But the one thing that you have to have a heightened sense of security on is search and seizure, okay? In addition to the immunity for everything else, there's a specific immunity for search and seizure. And it only applies if you are following the search and seizure policy of the school district, okay? So when it comes to search and seizure, you must follow that policy to the T. And I want to talk to you about that policy for a second. What the law on search and seizure says is this: if it is school board owned items, like lockers, the principal can walk down that hall and open up every locker. Or the principal can walk down the hall and open up every third locker and look in there. Why? Because the school board owns that. The student doesn't own it. And what the law says is when you don't own something, you shouldn't expect any privacy in it. So you as teachers should expect no privacy in what's on your computer. You should expect no privacy in what's in your desk. And a student should expect no privacy in their lockers or what's in their actual desk that they're sitting in, okay? But when it comes to your purse that is hanging in the locker if you're a student, or your purse that's inside of your desk if you are a teacher, then you do have an expectation of privacy there, because that is your personal item. And so you have a privacy interest in it. So the principal cannot come in and open up your purse and look at it. The principal can't open up that locker. Well, he can open up the locker, but he can't open up a purse that's in that locker. Can't open up a book bag that's in that locker. Can't look in the contents of a cell phone that may be in there, because that is the student's property, and they have an expectation of privacy, and your purse or your wallet as an employee has an expectation of privacy there too. Now, what we can do with a student is this: if we receive a report that a student rode to school this morning with John Geis, and John had a blue book bag and there was a pistol in it, he showed me that pistol. I can go open up John Geis's locker, I see a blue book bag there. And so I've got a credible student who's told me that I rode the bus with him. I checked the records. Yes, they ride the same bus. He told me it was a blue book bag. Open up the locker, there's a blue book bag. Well, 2 for 2. That gives me a reasonable suspicion to believe that I've got a credible report that I need to investigate. So I can open up that book bag and look for a pistol. Now, where you get in trouble is you open up that book bag and you look for a pistol and you see a cell phone, and then you start looking in the cell phone. You have then exceeded the reasonableness of your search. You're only authorized at this particular scenario to look for that pistol. So you couldn't go looking in a matchbox to see if there's any marijuana in the matchbox. You couldn't go looking in the cell phone to look at the pictures and the text messages. You could seriously and legitimately look for that pistol, but nothing else. So that's the first rule. If it's our property, we can look. Teachers can too. If it is their property, then we have to have some individualized suspicion that there has been a violation. So let's say that we've got a report that during class I lost $20 over here. What individualized suspicion do we have for those kids over there? Kids that are over here, there's no way they could have taken the money, most likely. So we wouldn't have the individualized suspicion to check their purses, their book bags, their pockets, and stuff like that. It's only those kids that we have a reasonable suspicion or a reasonable basis to believe that they may have stolen the property that we could do any conceivable search on. Now, the same thing applies when it comes to our employees and our drug testing. If you are in a safety-sensitive position, like a chemistry teacher, a custodian dealing with chemicals, if you're a bus driver, you can all be randomly drug tested. If you're just a regular teacher that is not involved in a safety-sensitive situation, we can drug test you if we have a reasonable suspicion to believe that you're intoxicated or under the influence. If you come to school with slurred speech, a lack of balance, odor of alcohol, then you can be tested. One of the weirdest cases I've had on that was in a parish not too far from here. A young lady and her boyfriend did not go home after school one day. They were missing. They were reported to the police as missing. And all night long, the parents, the police looked for them. They never found them. The next day, the boyfriend's truck pulled into school. They both got out of the truck, and they were staggering drunk. And so they came into the principal's office. The principal hugged them. At first, it was just so glad that they were alive and that nothing happened to them. But then it became obvious that, boy, they were drunk. Called the parents. The parents came down there and picked them up, and the parent of the little girl cursed the principal. "What do you mean you're suspending my child? She didn't drink alcohol on campus. You know, not that, thank goodness my child's safe, thank goodness that she's at school and that nothing happened to her. It's, you're a sorry principal for suspending my child because she's under the influence." She was so drunk that the SRO officer had to walk her and sit her down in the office. We've had other situations where students would leave campus, just cut school, and go do marijuana and come back on campus. And in those situations, we can discipline them because they're coming onto campus under the influence. We've actually had that case. Show of hands, how many of you do those referral forms that you send to the principal if a kid is in trouble? Y'all still using those referral forms? They may be electronic now. Those are very important documents. You must check everything that applies there. Now, JPAMs, are they on JPAMs? They may have a limit on the number of boxes that you can check. If you're dealing with an expulsion issue, though, principals, I think it's important enough to print that form off and sit down with that teacher and check all of them that can conceivably apply. We've had a case where a judge made a wrong decision, and I know I've told you about this, where the kids left campus, they did the marijuana, they came back onto campus under the influence. And when they were brought into the principal's office, they went to sleep. The parents called and he came and got them, but the principal checked use and possession of drugs. And the Second Circuit Shreveport reversed and put them back to school and said that you violated their due process rights. The court said that they did not do the drugs at school. And so the court said that you checked the wrong box, principal. So if I were sitting there with a principal, I would have checked the same box. But in addition, there are other boxes. You could check leaves campus without permission. You could check other serious offense, and then you would write under there. You can't just check other serious offense. You have to write the details. So you would check other serious offense, and you would put so-and-so left school without permission, came back onto campus under the influence of marijuana, which he admitted using. If a kid ever admits to the misconduct, put that on the referral form. That helps a lot. So that would have flown with the judge, but simply checking use and possession of drugs when they didn't use it on campus is going to get us in trouble. So that's a very, very serious form. All right. So as far as this immunity goes, if you're doing your job, you can't even be sued. If you're doing your job, the school board has to hire you a lawyer, has to pay all the defense costs associated with that. If it's a search and seizure issue, you must be following the search and seizure policy to the T in order to get that immunity. All right, many of you join professional associations. I saw my friend Ray Hodges when I came in the door. I am not here to bash those. They serve a good purpose. There's LAE, LFT, there's LACE, there's LAS. But please understand that the insurance that they provide you only kicks in if the school board goes bankrupt. So in other words, if you get in trouble at school and a student sues you, that insurance policy through LAE, LFT, LACE only kicks in if the school board doesn't have the money to pay. In other words, that policy is secondary. Now, there are other benefits to that to assist you if there is adverse job action against you. And I know they lobby in the legislature for new laws that you need, but I just want to be very clear on insurance. And that is that the school board's insurance applies first. Now, I just want to be totally honest with you when we're talking about this immunity. It does not apply if a parent goes and files a criminal charge against you. If I were you, who is my senator or representative, I'd want them to pass a law to address that. Let's say that you paddle a kid or something happens at school and the parents go and file a criminal charge against you and you're arrested. School board does not have to hire an attorney to represent you, doesn't have to reimburse you. It can be the most bogus complaint out there. Hopefully the DA is going to not prosecute you, and hopefully the sheriff is going to decline those charges, but not every parish has a good relationship with their DA and their sheriff. And so if a parent goes and says, look at my child's butt, he's bruised by the teacher beat him, I have seen all too many times the sheriff arrest the teacher. And so the law says that this indemnity and this defense and all is applicable if you are sued, but there is no protection for you if you're arrested because some parent goes and files a complaint against you. And that's where sometimes these associations can come in and help you, the LAEs, LFTs of the world. And it's one of these situations where the school board won't have insurance, we won't have a legal obligation to pay, and we can't pay. Because under the law on public funds, we have to have some legal obligation to pay a bill. And so when our auditors know that we have no legal obligation to pay your criminal defense attorney, so they will not allow us to do so. So again, just be cognizant of the fact that the parent can file a charge. Now, while we're talking about irate parents, let's talk about being recorded. I think I've told many of you before, and I'll say it again. Be careful what you say on the phone or in person to parents. Operate under the assumption that you're being recorded and that what you say may be heard by your spouse, your superintendent, by the board, or by anyone. Okay? Because a parent does not have to tell you that they're recorded. Louisiana is a one-party state, and as long as one person consents to the recording, then that's good enough. I found out the hard way that is not the law in Maryland. In Maryland, both parties have to consent to recording. And I had to get a lawyer in the state of Maryland one time. I had a client that recorded some telephone calls, and we were in the state of Maryland, and we were in a deposition, and my client was resigned from a bank in Maryland. And this witness we were deposing called him and said, Ed, I heard you resigned. That's the best thing you could ever do. You were working for a bunch of crooks. You know, I was worried about you. How could you have worked there 5 years as bad as these people were? That's the best thing you ever did, and I wish you good luck. He recorded that conversation. Well, when he resigned and went to work with another bank, the old bank that he worked for sued him and said, "You're in breach of our non-competition agreement." And guess who they listed as one of their star witnesses? That person that called me. And that person took the oath and was testifying, "I can't believe that Ed left." They were treating him like royalty. They were treating him like an owner. They had given him all this information. This is a great place to work. You know, he signed an agreement and he was in breach of that contract when he left because he had no good reason to leave. So I get the person and they're testifying, and I say, "Miss So-and-so, you just testified that you blame my client for leaving." "That's right. He is in breach of his contract." "And you don't believe that he had good grounds to leave?" "No, I do not." "And you believe that the people he was working for are good people, good moral people?" "Yes, I do." "And have you always held that opinion of them?" "Yes, I have." I had that tape queued up. And I said, "Ma'am, do you realize you're testifying under oath?" "Yes, I am." "Do you recall having visited with my client shortly after he resigned?" "No, sir." So let me refresh your memory. Boom. And I hit that tape. And when I hit that tape, all hell broke loose. Every lawyer in there from Maryland jumped up and started going crazy on me. "Did your client have consent to record this?" And we took a little side break and found out that no, there was no consent. So anyway, we ended that deposition. I got in my Uber, went to the plane. Well, anyway, we had to go back to Maryland for the next deposition, and I had to go. And I knew that they were going to probably arrest me and my client when we got up there. So we went ahead, we called a bail bondsman. I hired me a lawyer in Maryland. Linda Eubank, that works with me, suddenly she couldn't go on this deposition. She had been to every deposition we'd had that day, but suddenly, for some reason, she had a conflict. So anyway, I tried to patch it up before that next trip. So when we got to the deposition location, I drove round and round that sucker about 20 minutes looking for a cop car. And that was one of the shortest depositions that I've ever taken on the way back up there. We took that deposition and got out of there. But look, some states are not like Louisiana. And you have to tell people when you're recording, but not in Louisiana. So a person can walk into that parent-teacher conference and record it. And in one situation, we had a principal that was having a parent-teacher conference, and the parent was talking about the teacher, and the principal said something like, "Well, that's Miss So-and-so. You know, she's been here for a long time. I can't do anything about her." "Well, that's so. Well, what about this one?" "Well, that's related to a board member." You know, and it's like, wake up, you idiot! You can see that parent lobbing those questions up there. You know, so all that was being recorded. So you're talking about a problem. The principal had a problem. So be careful that you're being recorded. All right. Let's see. I want to talk to you a little bit about video cameras and FERPA, and it gets back to the student confidentiality. You know, there are cameras everywhere these days. If you were employed in Bienville Parish, every classroom has a camera in it. The superintendent's office has a total bank of cameras. He's got like 4 monitors there. He can click and go to every single classroom. The only place that they do not have cameras are in the locker rooms and the bathrooms. They can take that mouse and that camera will pan up, down, side by side. In the halls, they can literally take that mouse and just move that camera anywhere in the hall they want to. So the courts have said that as long as they disclose to the people that, hey, when you enter these premises, you're subject to video recording, then you can do that. Now, the problem that comes up is, what about the parent that wants to see their child? My child wouldn't do that. You're saying my child started that fight? Not my child. My child wouldn't do that. My grandfather always told me never to say what your dog or your kid won't do, okay? Because they will do it. But those parents sometimes think that their child is an angel and would not have started that fight. So, under FERPA, the Federal Educational Right to Privacy Act, certain things we can show, certain things we cannot. We can release directory information, and we have to have a notice that goes to our parents each year saying what directory information is. Generally, that's the name and maybe the address of the student. Sometimes we'll go ahead and put pictures appearing in the yearbook and stuff like that. But as a general rule, we do not show wholesale the videos from the schools, because in addition to that parent's child, there are going to be other children that are there. Now, we will release that video if it is subject to a subpoena, or there's a law enforcement need for it. The law enforcement can get a subpoena for that, and so we can do things that way. Also, there's now technology that will allow us to put a video on the screen. We can take the mouse, set a border around the student we want to see, and then it blurs everything else. And I hear that technology is not that expensive. There are a lot of times where we would love to show the parent just how bad their child was. But if we adopt and purchase that technology, then we could do so. So it's not the fact that we can't show the kid, the parent of their particular kid. It's the fact that all those other kids that are there. But with this technology, you can go in, put the box around the particular kid that you want to see. It blurs out everything else. We could do something that way. Now, I also mention this to you because a lot of times I have had teachers videoing in their classroom with their phone and stuff like that, and they want to post it on Facebook. Sometimes they don't ask for permission. Sometimes they don't even think. They just place it on Facebook, and that can cause a big problem. So it would be a potential FERPA violation. Now, the penalty for violating FERPA is that you stand to lose your federal funds. So this is something that really gets our attention, and we don't want to be involved with a FERPA violation. All right. Now that's the rest of the time, or a large percent of the time between now and when we leave here, we're going to spend on personnel issues. It's even more boring than what we've done before, but I think it's important for you to understand. I've already told you that every employee in the district needs to be evaluated and observed. That's because of the real law in effect. The policy that you should be aware of is GBRN for terminations and for discipline. And basically, what it says now is that the superintendent handles all those decisions. So let's start for the positions that do not require a teaching certificate. That's your custodians, your food service workers, your school secretaries. Basically, you are evaluated by your principal or your immediate supervisor. And if any of you get in trouble, then they will follow that policy. And there will be a specific paragraph in that policy that says, these are your rights. This is what happens in the event that you are in a situation that involves discipline. And primarily it's left to the superintendent. Some districts allow that category to go to the boards, but it's very little job protection there. And you're sitting here and I can see it on some of your faces. Why are we talking about that? That's a gloomy topic to talk about terminating someone. I think it's important for you to understand how very little protection that you have, okay? You're not going to hear a school board's lawyer getting up talking about terminating people and rights and how many rights they have and how few they have. But I think as a person, and being candid with you, for those of you that fall within that classification, life is tenuous and job security is tenuous. So that's why we need to address any concerns immediately. That's why we need to hopefully avoid any concerns, because There's no job protection there for you, okay? Just being brutally honest with you. Now, when we move up to our non-tenured teachers, and our non-tenured teachers are those that have not been highly effective yet for 5 out of 6 years, there's a lot of non-tenured teachers in the district. And what the law says for you non-tenured is that you can be terminated for any valid reason. So one time I said, what in the world is a valid reason? So I spent a couple of hours researching what is a valid reason. And I found one case out of Caldwell Parish. It is the only case that I could find, and it was in Caldwell Parish. And the court went on for 3 pages and said this: in conclusion, we find that a valid reason is a sound and sufficient reason. What in the heck is that? Okay? And so what I generally tell folks is, we know that incompetency is grounds for termination. We know that dishonesty, and we know neglect of duty. Those are grounds for termination for a tenured teacher. I try to tell our non-tenured folks, those are the same type of things that are going to get you in trouble too. Not reporting your absences, not coming to school and reporting to your duty post, not turning in job descriptions, disobeying the directives from your supervisors and principals. We had a case in Bossier called Wise v. Bossier Parish School Board. Miss Wise was at the last room on the hall in elementary school. It was a long ways up to the principal's office. They had told her repeatedly, you have to send a kid to the office. Buzz the office on the phone. Let us know that the kid's coming, or send somebody with the kid. Just don't let these are little kids, go all the way to the office unattended. And she kept doing it. And she kept doing it. And they wrote her up, and they gave her written warnings. She wasn't doing some things as far as her grade book was concerned. So the combination of those 2 things, not following the directives of the principal relative to sending kids to the office and not reporting certain things in her grade book, the court said she was a tenured teacher, and that was sufficient to terminate her. Okay? So, support employees without a certificate, you look at that GBRN policy, and it's not much protection. Non-tenured teachers, what's going to happen is we're going to look to see if you've engaged in something that is close to neglect of duty, dishonesty, or an incompetency. And if the superintendent believes that you have, you will get a letter from the superintendent. Let's say, dear Mr. Geis, I am considering disciplinary action against you, which may include your termination. I am contemplating this action for the following reasons. And the superintendent's going to lay out what the reasons are. And you're going to have 7 days to respond to that letter. The superintendent gets your response and reads it and considers it. And if he feels that some type of discipline, like suspension without pay, or even termination is warranted, he'll write you back and say, dear Mr. Geis, I've considered your response and everything you've said. Unfortunately, I feel that it is not sufficient to justify your actions. Accordingly, I'm suspending you without pay for 10 days, or accordingly, I'm terminating your employment. Or he could say, I've considered your response and I understand why you did what you did. And, in the future, you should act differently. So you're entitled to a response from him. It could be a warning, it could be suspension with or without pay, it could be termination. But you only get the benefit of a 7 days period of time to respond in writing. And then if you do not agree with what he does, you get to appeal to the court, but you only have 60 days. 60 days to do that. And the court is supposed to affirm the decision of the superintendent if there's any evidence in support of what the superintendent did. So you don't get a new trial at the court. So I hope you see the theme that's developing. Board members already understand what Act 1 did to them in Act 570. But board members aren't the only one. And because it affected the rights of everybody in this room. And I think it unfairly focuses all the attention on the superintendent. I don't care if it's John Galat, Jane Doe, John Guy sitting in that chair. They're going to be unpopular in certain circles. And that's because, in my opinion, there was a design the state did not, appreciate and respect school boards. The state thought they could do better among the teaching ranks, and they tried to make it easy to get rid of people. And so this is what we're left with. So we've covered support employees. We talked about non-tenured teachers. Let's talk about tenured teachers. Those of you that had tenure prior to Act 1 in 2012 still keep tenure. Those of you that have been highly effective for 5 out of the last 6 years have earned your tenure. And you cannot be disciplined or you cannot be terminated unless they give you a letter setting out the reasons. But guess what? You get 10 days to respond instead of 7. Okay? So membership has its privileges. You get 10 days instead of 7. But you also have one additional right, and that is the right to a hearing before a disciplinary hearing officer. Your non-tenured teachers don't get that right. But you can ask for a hearing before a disciplinary hearing officer. And you can have an attorney, and you can have a hearing and present your evidence. But if there's any evidence that you have done wrong, then the disciplinary hearing officer is supposed to enforce the decision of the superintendent. Let me tell you about a case that I had recently where a teacher had been selected for a drug test. This particular teacher had a history of drug problems, and as part of retaining her job, she agreed with the school board that I'll be subject to drug testing at any time. So they had 3 or 4 teachers like that. So every time there was a drug test, one of them would be randomly drawn and added to the group of bus drivers that were going in for testing. Well, this teacher's number came up. The school board central office called the school and said, tomorrow send Miss so-and-so to drug testing. The principal got that message, and he called the teacher and said, hey, if I tested you, are you going to test hot? And the teacher said, yeah. He said, well, look, you better not come to school tomorrow. You better not come to school tomorrow. Because guess what? Your number's up. They're going to test you tomorrow. So the teacher doesn't come to school for about a week. Then when the teacher comes back, guess what his test was? He tested clean. Or she tested clean. So we had to have a hearing on that situation. And so we had the school secretary. Those school secretaries know a lot. So we had the school secretary. We had witnesses that told, so the lady teacher told some of the other teachers, he called me and told me I was having a test. And so we had all those witnesses that we called before the hearing officer, and the hearing officer said, boom. All the superintendent had to do is to show me there was some evidence. The superintendent took the stand and said, look, during our investigation, I talked with the principal, I talked with the teacher, I talked with these other witnesses, and I thought these people were telling me the truth. So I found them to be more credible than the principal. So the hearing officer affirmed it. Interestingly, we had the cameras that day. So we knew when the email went to the principal to tell him about the drug test, and then guess what? You could see the principal in the hall going down to the teacher's room. So all that circumstantial evidence. So that's just an example of how the process works. And then, as I told you, for our principals, our supervisors, our administrators, it's the same exact thing that applies for our tenured teachers for them. And then finally, our bus drivers. They just changed the law last year for you tenured bus drivers. Tenured bus drivers get a 10-day letter too. So tenured teachers, principals, administrators, tenured bus drivers, you're all getting 10-day letters, 7-day letters for your non-tenured teachers, and then possibly GBRN for your support employees. Now, there's one final thing that I want to spend some time on, and then we're going to take our final break. And I apologize to you for having to take so many breaks. My leg is still a problem here. Intensive assistance. Have you all heard about remediation and intensive assistance plan? What this means is that it only applies to teachers and some administrators. But if you are a tenured or non-tenured teacher and your supervisor or your principal thinks that you're having a problem with your performance, the law says that before we take disciplinary action against you, if it is incompetency-based, that we have to try to help you overcome your problem. So if you get mad at your principal and you flip him the finger, we don't have to offer you intensive. We don't have to say, now, Johnny, you cannot flip the finger at your principal. If you steal a bunch of money, we don't have to say, look, we're going to put you on an assistance plan to teach you that you can't steal from us. We don't have to do that. Now, what I'm talking about, folks, is if you're a teacher and you know the subject matter up here, but you can't control the kids in your classroom, you've got classroom management control issues, then we are going to try to help you with that, okay? What that generally means is that we're going to send you to watch other teachers that are good at it and ask you to observe what they do and what techniques they utilize and come back to your classroom and implement it. We're going to ask to see your lesson plans and help you with those lesson plans. It is called an intensive assistance plan. So many teachers view it as some form of disciplinary action. It is not disciplinary action, it is an assistance plan. Now, if you are not successful and you do not improve, then you may be placed on a second level of intensive assistance, or you may be terminated ultimately. But you must go through the intensive assistance plan, or we must offer you the intensive assistance plan if you have a competency-based issue. Now, for those of you, how many first-year teachers do we have out here? Got a few of y'all. I know that you may have heard me tell you about the lady that I had in Webster Parish. Classroom management control was her big deal. This is a system where they use leaf blowers to blow out her classroom because she had so much trash on the floor. Okay? So much trash. They kept burning up their vacuum cleaners. And so they had tile floor in the hall, so they used the leaf blowers to blow the stuff out into the hall and then sweep it up. And she's the one that walked next door to the teacher next to her. And so you come tell my kids they got to mind me? Okay. All right. So when we have these type problems, you're going to get intensive assistance. And please, work with us. What were those grounds for terminating a tenured teacher? Incompetence, willful neglect of duty, and dishonesty. If you're accused of incompetency, we will work with you on the intensive assistance plan. But if you refuse the intensive assistance plan and say, I'm not going to do it, then you now have a charge of incompetency and neglect of duty. That's what happened to me in Claiborne Parish with this teacher there. We placed her on an intensive assistance plan. She was teaching a math class, but she persisted in having a whole week of instruction on classical music and the composers. She taught a week in a math class of music, classical music and composers, and would play the music and would talk about this is Handel. Handel was born in such and such, and would talk about that. She would cut the lights off. So we placed her on an intensive assistance plan. I've been teaching for 25 years, and you telling me I don't know how to teach? I'm not going to do that. You know, so suddenly we go from a competency-based issue to a neglect of duty situation. She refused to sign any documents, and that got her in trouble too. You know, in the Personnel Files Act, when a principal comes to you, they're supposed to give you a copy of the document. Guys, you can take that one home with you, that's yours. Here's the original, sign the original, it's going in your personnel file. She said, I'm not gonna do it. I don't agree with that, I'm not signing it. So I told the principal to call in his secretary. The secretary writes on there, this document was offered to Mr. Geis. He refused to sign it, the principal signs it, and then the secretary signs it, and it goes in the personnel file. Then I told the principal to go back into his computer and write up a second reprimand that says, Dear Mr. Geis, on such date, I directed you to sign the document that was provided to you in accordance with the Personnel Files Act. I gave you this directive, yet you refused to do so. This is neglect of duty. Because under this Personnel Files Act, it says, when presented with the original and a copy, the employee shall sign it. Your signature doesn't mean you agree with it. And you have the right to file a response and rebuttal to that document if you think that it's wrong. But you can't just say, I'm not going to sign it. So that was an example on intensive assistance plan where a teacher simply changed it from an incompetency-based issue to an incompetency plus a neglect of duty situation. And she was ultimately terminated. And we did the hearing for the disciplinary hearing officer, and that decision, the superintendent was affirmed. All right, we're going to be back in here at 11 o'clock, and I want you to have some more questions for me, and we'll go from there.